Welcome to the Melling Law Self-Help Library. Today we're going to talk about the Power of Attorney form and how to fill it out yourself. The Power of Attorney is a document that allows you to appoint someone to make financial decisions and assume your life financially if you're ever in a position where you cannot do so for yourself. Now, there are some important things to know as you're filling it out, like, for example, unless you're affirmatively stating otherwise, it is presumed to be effective immediately, not necessarily upon you losing capacity to sign or conduct these transactions on your own. So we'll go through the form step by step, talk about things you need to know as you're filling it out to make sure that your wishes are honored and that it has the intended effect. This is the standard Power of Attorney form. The language is straight from the statute, so regardless of the form you're looking at, this is what the standard states form looks like. This first little part is really important because it has all the disclaimers that you need to know. If there's anything that doesn't line up with your expectations, you need to make sure that you've either accounted for that or know that it's not going to line up with what you want it to do. So read that very carefully. But then this bottom part, it's just I, and then your name, are going to make the following person as your agent. And then you name your agent, list your agent's address, telephone number, and then at the bottom also put your name and your initials. On the next page, you designate your successor agents. This is in case your agent is unwilling or unable to act on your behalf. You name your successor agent, the address, telephone number, and then a second successor agent. If you have co-agents, I would, instead of listing that your original agent or successor agent are supposed to serve together, I would just list them both on the same section. So naming a successor agent, a lot of people, what they'll do actually is they'll name their spouse as their primary agent, and then maybe their kids as co-agents as successors. So on name of successor agent, you would do Bob and Steve, and then addresses, you'd list both of their addresses and both of their telephone numbers. Now on grants of general authority, this is really what we're granting to the agent as far as powers go. The powers, if you read the Uniform Power of Attorney Act, you'll see that each of these little check boxes, and really you're supposed to initial, not check, but initial each of those boxes that you want to apply. But each of them has several lines of statute behind it defining what exactly is included and what is not included in each of those powers. What really happens here is these are kind of the basic things that you would generally expect an agent to be able to handle according to a power of attorney. So by initialing there at the bottom where it says all preceding subjects, what you're really doing is you're bypassing any kind of powers that might be included in a court-ordered conservatorship. So if you're filling this out for estate planning purposes and you're worried about potentially losing capacity down the road, this all preceding subjects is what you're going to want to initial. On your next page, we have grants of specific authority. Now these are what we would do only in certain situations. You really shouldn't initial any of these without the advice of an attorney. Even with my clients, generally the only ones we're initialing are this one here, where we're authorizing another person to exercise the authority granted under the power of attorney. And that's because sometimes someone may lose capacity, develop dementia, but they'll still be alive for another 5 to 10 years. And their agent may become terminally ill or need to do something, and rather than subjecting the estate to a conservatorship, that person can simply delegate these powers out to another person. And then obviously we're going to put a limitation on the agent's authority by law that that there's no self-dealing. Under special instructions, you may decide to write some special instructions. Some common special instructions are going to address the things that were on the first page that might not line up with what you want as far as how this form is effective, or what about this form will be effective. Those may include things like agent compensation. By default, the agent will be compensated for services rendered, and you can limit that to merely being effective as to reimbursement for expenses. You might also, under this power of attorney, co-agents are not required to work together or work in concert, but actually have separate authority to act independently. If you want to force them to work together and act in concert, then you would also want to include that in the special instructions. And then finally, this last page, we'll usually have it effective immediately unless we've stated otherwise in the special instructions, like only becoming effective upon incapacity as defined by statute, or only becoming effective if someone has been deemed incompetent by their physician. And then nomination of conservator or guardian. I generally don't include this in this form. So my forms say none appointed in this instrument. If you want to change that, you can feel free to do so. And then all that's left is to sign and date it. So list your name, address, and phone number, and then sign this in front of a notary. Make sure the notary is there when you sign the bottom of it. And that's it for this form. If you have any other questions, you can always reach us at mellinglaw.com or at 435-572-0807.